English legal dictation 90 words per minute. Ready? Start. The appellant is presently undergoing the sentence in the said case, and as on today he has undergone actual sentence of 8 years and 24 days. As per the custody certificate filed in court, identification have been in common use for a very long time for the object of placing a suspect in a line-up with other persons. For identification is to find out whether he is perpetrator of the crime. This is all the more necessary where the name of the offender is not mentioned by those who claim to be eyewitnesses of the incident, but they claim that although they did not know him earlier, they could recall his features in sufficient details and would be able to identify him if and when they happened to see him. The holding of a test identification in such cases is as much in the interest of the investigating agency or the prosecution as in the interest of the suspect or the accused. For while it enables the investigating officer to ascertain the correctness or otherwise of the claim of those witnesses who claim to have seen the crime and their capacity to identify him and thereby fill the gap in the investigation regarding the identify of the culprit, it saves the suspect or the accused from the sudden risk of being identified in the dock by the self-same witnesses during the course of the trial. The line-up of the suspect in a test identification parade is therefore a workable way of testing the memory and veracity of witnesses in such cases, and has worked well in actual practice. In this case, none of the accused was arrested from the spot. There is no explanation on record as to how the police officials identified the accused. There is nothing on record to suggest that the members of the police party knew the accused earlier. If so, the context as to how the police party knew them has not been cited. No test identification parade was conducted by the prosecution, so the identify of the accused who ran away from the spot could not be matched with the present accused who were suspected to be the actual culprits. There are chances of mistaken identify in this case. The ASI who allegedly recognized the accused was not having any friendship or thick relations with the present accused, leaving no doubt about the identity of the ran away accused. There is possibility of framing the present accused merely on suspicion. It is thus argued by learned counsel for the appellant that even on a plain perusal of this document, it is clear that the appellant was never informed. Stop.